I feel fine. It's just my hands that are. And now there's a gnat or a fly flying around. I know it was. Good morning. You're Norberto Armenta, and this is cause number 25 DCCR 0168. Mr. Armenta was previously in court, entered a plea of guilty to driving while intoxicated, third or more, in addition to pleading true to prior offenses, making this a second-degree felony offense for punishment purposes. And there was an agreement of a cap of 12 years and to dismiss the evading as part of that plea agreement. I've received the pre-sentence report as well as a whole packet that the defense provided that has certificates and different things that I have reviewed. Has everyone had an opportunity to review the pre-sentence report as well as those other documents?
Yes, Your Honor.
I have.
Are there any additions or corrections?
No, ma'am. No, Your Honor.
All right, Mr. Kimler, you may proceed.
Well, Your Honor, we start as usual with the criminal history, which is rather extensive, Mr. Armenta. I will say I've spoken to him at the jail extensively and reviewed the case. And this is really an unusual fact situation in that he's the one that called 911 on himself in the vehicle because he was having I thought, and I'll let him explain it to you what the reasons that he did call concerns. And as a result of that, received the DWI. The evading detention, Mr. Armenta, is from Harris County and has had some bad experiences with law enforcement. I think there was a low speed failure to stop. They did deploy the spike strip and he ultimately came to a stop. And he related to me that he was in fear, I guess, of law enforcement and wanted to get to a spot where he would feel safe pulling over, and that's what he did. But I'll let him elaborate as to his thinking on that.
Well, but what you're thinking is on that really isn't going to matter. You were on cocaine and Xanax at a minimum that day, so your thinking was not clear because you were under the influence of a lot of things in driving.
That's
okay.
correct, Your Honor. And I think that he relapsed, I would say, because he has indicated, and I guess enough factually demonstrated that he is trying to maintain his sobriety through our religious faith-based rehab, or I'll say programming, but efforts to maintain his sobriety. And the certificates that have been provided to the court were obtained by him while he was in custody in Harris County Jail, awaiting transfer over here. He does have a motion to revoke probation in Harris County for a DWI that will be resolved after this case is disposed of. In the VSI, again, relating to criminal history, there's some self-reporting that Mr. Armenta did as far as gang affiliations. I want the court to know, too, that these are self-reported by Mr. Armenta. He didn't have to inform the probation officer. These are things that he told the probation officer in good faith about his history because he wanted to be honest about things. It certainly doesn't make him look good or any better, but it was important to him that he be honest about that. We're not asking for probation on this. It's a 12-year cap, and I think Mr. Armenta really is in a better position than I am to give the court an indication of where he is in his life as far as his recovery, what his plans are, what his efforts have been. So I would defer to him at this point to talk to the judge and let her know where you are.
Did she get my college papers?
Yes, and he also, yes, there's some paperwork. He was in San Jacinto College, I think.
Right.
Yes, ma'am. Good morning. My whole life, I've been a criminal all my whole life. 2015, I began to change my life. I gave myself to God, and there's not much I can say, but I never, ever since I started doing recovery and trying to change my life, I had difficulties, and I was doing good and I relapsed. And Your Honor, I never dialed 911. And what they're teaching us is to take responsibility for your actions. And, and that's one thing that I wanted to do is I wanted to help, and I wanted to get locked up for a while and take classes, and that's what I've done before. And that's the only way I knew how to get help. And I apologize to the courtroom for my mistakes that I've made, but I've never called 911 on myself, and I feel like that's a big step as well. As doesn't make it any better, I wasn't asking for probation, 2 years, 3 years, 4 years. I asked for 5 because I felt like, I don't know if that was a good punishment for me, but I felt like I needed to get away for a while from wrong that I did, from my mistakes, and I'll take full responsibility for my actions. And I'm sorry for what I caused. But I do have a daughter, and she's asking for me, and I'm just trying to better myself for her. And I never thought that changing my life would have to deal with me being an addict, and that's what I'm dealing with now.
Thank you.
Sorry.
Thank you. Ms. Malfino?
Judge, obviously, his criminal history dictates that somewhere in the range of 10 to 12 years would be appropriate for him and would have been a sentence that was mitigated by the cap. I do appreciate his honesty. It's not what we typically hear from a defendant. Usually it's the excuses. I appreciate that he's not even asking for probation and insulting the court in that way, so I'll defer to what he thinks is best.
So, Mr. Armenta, I make notes and go through the pre-sentence reports. Obviously, before court, I use a highlighter to highlight convictions and things, and usually the prettier it looks, the worse it is. With highlighting, yours does not look good. Your criminal history, like you said, is ridiculous.
He stood before the judge admitting everything, the relapse, the fear, the criminal past. No excuses, just truth. But honesty alone couldn't save him from the sentence that followed.
I appreciate what you're trying to do now. Obviously, it's a little late, or a lot late, but it's Ms. Malfino's right. People don't take responsibility. I had a note on here for pretty much what she said, that 10 to 12 was probably the right thing to do. I think I'm inclined to give something for what you are trying to do, but 5 years is not going to be it. So I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, third or more, find those prior offense true, sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir. Hopefully you'll continue doing what you have been. Ms. Holmes on Claudia Villalobos. Let's see.
Thank you, Your Honor.
Yes, sir. I'll get you in just a second. Kimler, let's see. He's here. Mr. Kimler, you have Colton Armstrong, the sentencing. Okay, I'm going to have to X out of this whole thing. I might have to get signed back in now.
I brought you a letter on him yesterday. Did you get your letter?
He got attached to someone else's PSI on accident next door, but I have to take a look at that.
I brought that to you. Marshall? No, the other.
All right, are you Colton Armstrong?
Yes, ma'am.
And Mr. Armstrong was previously in court and cause number 25 DCCR 0002, entered a plea of guilty to theft of property enhanced to a third-degree felony. There was an agreement for a 10-year term to be probated for 10 years. There was not going to be a fine and $20,000 in restitution. Is that correct, that that was the agreement?
I thought it was, is it 10 over 10?
That's what I had, just 10
Okay,
over 10
that's
with the
fine.
20,000 in restitution.
Yeah. And then I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your
I
Honor.
have it.
What is the status of the Hardin County case?
Pending.
I have made multiple attempts to contact Mr. Hopper over there to know that, I'm sorry.
Okay,
I've spoken with him about it. He doesn't, at this stage, isn't offering probation. I think what I would do, once Mr. Armstrong gets granted probation here, he would post a bond on that case and then just set it on the regular trial docket in Judge Thomas's court. And offers tend to change over the course of the pendency of the case. I think Mr. Hopper's going to retire probably before the case will be reached for trial.
And Judge, our position.
I'm not
I know.
being flippant. It'll be assigned to someone else.
Our
yeah,
position on this was to make this offer obviously conditioned on the amount of restitution and his paying the restitution. As you can see, he pled to more than one paragraph, which elevated it to
Sure.
10 over 10. And we would, of course, be asking for the full 10 on the revocation.
right. And y'all also, I guess, understand the recommendation that was made after the substance abuse assessment with regard to ISF cognitive and then JCDI after.
I would let Mr. Armstrong speak to that, Your Honor. I think and in counseling with him, he advises that he thinks he's at a point now where he has a new son, new child, needs to be there for his family to support.
Well, based on the criminal history and the 2 different probations that have already been revoked, if I'm going to go along with the agreement, then I want him to have every tool to be successful. And that's what's going to happen. So it's not necessarily meant to be a punishment, but if that's what's recommended, then they're the professionals, and I want to give you all those tools so that you can be professional, be there for yourself, your kid, and everything else. So then, anything else?
Cognitive track or something.
Cognitive track, and then JCDI as aftercare. So there, he gets both.
The problem there, Your Honor, is that he does have a pending case in Hardin County, so I don't know that he'll be able to go to that.
He's going to have to be, once I'm done, they'll transport him over there because there will be a hold here, and he'll have to get that case taken care of before he goes, one way or the other.
So if he were to post bond, I guess he would still be.
He won't have a bond. He won't be able to get out in this
That's what I'm
case
saying.
because he'll have an ISF hold.
Okay.
So, and if something happens and that case does not get resolved, file something, let me know, and depending on the time frame that he's sitting, I might reconsider, but I want to at least order that, and then we'll go from there.
Since he's getting probation here, that may impact.
Right. If it doesn't impact it and it's going to get set on some docket that doesn't get taken care of for however, long, then just let me know. And then potentially I would hold it in abeyance, the ISF, if he has to go sit over there for a
With a lifetime of offenses and a fresh DWI on cocaine and Xanax, he begged for accountability, not mercy. The judge acknowledged his honesty, then delivered 8 years in state prison.
We're also consider imposing a trespass warning for all TNT record locations and the use of any and all of their services. I know they have multiple locations and businesses here in the area.
Just stay away from TNT.
All right, so here's what I'm going to do, Mr. Armstrong. I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property enhanced to a third degree. sentence you to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. There will not be a fine. You are ordered to pay $20,000 in restitution and to follow all of the rules and conditions of probation. Sorry. Does anybody else see that? There's a bug flying around. I feel like I look crazy. You're going to be ordered to go to the cognitive track of ISF and then through the JCDI program as aftercare, which is an outpatient treatment program. So you'll be transported over to Hardin County. If something gets worked out once you get there, then you'll go straight from there to ISF. If for some reason that doesn't get worked out and things are going slow, Mr. Kimler will get in touch with me and we'll reconsider the ISF. I want you to go because I think it's good for you. I want you to start getting your GED. I'm going to order that as a condition of your probation, you are required to, once you're out, and there might even be the opportunity in ISF to start that, I'm not sure. But if not, once you're out, within 30 days of being out, I want you to start that program. Again, that's going to be helpful for you, for your children, to get better jobs, and so that is part of your probation. You are ordered to not be on the premises of or use the services of TNT Wrecker as a condition of your probation also. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And I don't know, I'm kind of reconsidering. With the Hardin County stuff, I'm going to do this. Listen, hang on. Listen, this is what I'm going to do, just because I know that could take a while over there. I'm going to hold ISF in abeyance, which means you don't have to go to ISF. So you will be able to make bond. You will be ordered to immediately start the JCDI program, but you're going to have to change your behavior on your own without that 90-day program. Here's what we're not going to do. If I give you this opportunity and you do get a probation over there and you're getting out and you start making bad decisions again, you're old enough to be making better decisions. The argument doesn't need to be to come in and go, well, now I send me to ISF. It's probably going to be a revocation. It could be ISF, it could be a revocation, but you need to make those changes for good in your own life. Take advantage of whatever probation has to offer you. Okay? All right. Good luck to you. You can go back with the bailiff.
I'll be